This is U.S. Immigration Attorney Sharifa Tharp. I'm here live to take your U.S. immigration related questions. Put your questions in the comments now so that I can answer your questions. We've had a good day today, so more work permits came in today. We got yesterday. We got a number of them last week. So obviously, the process is rolling forward full force, and we're really happy about that, happy about the impact that these work permits are making on our clients. These are T visa work permits, and our clients have 4-year work permits while they wait for a final decision in their T visa application. So it's a life-changing step in the process that allows our clients to become stable, to get protection from removal, and also to be able to get better jobs and to support their family and to basically just basically achieve the goals, the personal goals that they want to achieve. So it's not just about a card, it's also about what it can do for the individual who gets it. And this is why we do what we do. All right, so today I just want to focus on questions. So put your questions in the comment and I will go ahead and answer your questions. And I see a number of them coming in. All right, so can I do I-912 for the I-485 and just pay lawyer fees? So usually the I-485 is not eligible for the fee waiver. Is EB1 still working? Yes, EB1 is extraordinary ability and it's still working. Yes, it's still moving forward. At this time, the green card processes are still in place. It's still moving forward, guys. Don't listen to the noise. Make sure you're getting proper legal advice about what you qualify for and how to move forward. Because that's the biggest thing, is that you can end up losing out if you listen to, I like to call them the village lawyer, right? The person that comes on at, in your, circle, they're telling you, they're just basically negative. They don't really know what's going on. They're coming up with assumptions based on what's in the news and giving you that information. Take it straight from an attorney who is obligated to give you the most accurate legal advice that they can. All right, keep putting the questions in the comments. How to extend DL with pending status. So usually that's a driver's license. So usually you get an extension letter to show that you have an extension, or you have your work permit. You'd have to use that to go and get the driver's license extension. Can you assist me to put my children's adjustment of status? One's 21 and the other is 16. Absolutely. So we help with that. The first thing we have to do, though, is we have to understand whether you qualify, how this process is going to look for you, what the processing times potentially could be. Now, I'm concerned about your 21-year-old, because you have a 21-year-old. Once they hit 21, they're no longer considered a child. They have to be under 21. Your 16-year-old is still clearly considered a child, and we could see what they qualify for. It just depends on whether you're a permanent resident or a U.S. citizen. But keep in mind, even as a permanent resident, the priority date now is current, so you can still apply and get through a faster process. Why are work permits taking so long? I have received my receipt notice since October 2025, still have not received the card. Yes, just across the board, things are taking longer and it's very frustrating. But that's the nature of the game right now, and you just have to be prepared for it. I think going in, please educate yourself about processing times. I would say don't let processing times stop you from moving forward, though. Because if my clients looked at processing times back then, which a year ago, I would say even a year ago, the processing times for work permits is pretty much the same. It's just that going in, you expect that the work permit is going to be coming in a month or 2 months, and instead it takes 6 months, it takes 8 months, it can take 12 months. But had my clients a year ago, after I prepared them for the processing times, if they had said, absolutely not, I'm not doing this process because it takes too long, they would not have their work permit right now. Right now, these same clients now have their work permits, right? Because they had the mindset that they're going to push forward with a process that they qualify for. They're looking at the long-term benefits of this. They're not necessarily looking at at short term. So you have to also just make sure you're thinking long term and you're not short sighted in the process. All right, kindly talk about the U visa waiver and when is it filed during the AOS process, as it's discretionary, what are approval possibilities if admissibility is false claim of citizenship. So the U visa is for victims of certain crime. And the thing about the U visa is that the processing time takes very long. In the meantime, they will issue deferred action, which is like a form of protection, and give you a work permit while you wait. It's a 4-year work permit, and you're gonna keep renewing it until your U visa can finally be decided. The thing about this is, you know, you're gonna have to wait a while. Now, when it comes to the waiver, that's when they decide. They're gonna decide the waiver 10 years from now. The deferred action is discretionary. So what that means is that if they do see something in your background that concerns them, usually a criminal record or a removal order, they likely will deny the deferred action. However, when it comes to the waiver, I would say my experience with the waiver for something like false claim to citizenship is they tend to be, I wouldn't say lenient, but they tend to really consider all the factors. And so, for example, if the false claim to citizenship is linked in some way to your victimization, then it's more likely that's gonna be a mitigating factor that's gonna allow the officer to say, okay, they can see why that happened and grant the waiver. I have had the experience, for example, with the T visa, of getting waivers approved for even permanent bars. And that's why if you qualify for T visa, the U visa, it is something, and you have an inadmissibility, it can actually help you to overcome that inadmissibility, overcome that past violation, and still move forward with your process, get the green card, and get citizenship anyway. So, being a green card holder, how long before I can file for someone? So it depends on how you got your green card. Usually, if you got your green card through a parent, through employment, you can apply and you qualify to apply for your children, your spouse. You can apply for them at any point, the day after you become a green card holder. However, if you got married to a U.S. citizen and you got divorced from the U.S. citizen within 5 years of obtaining the green card, they're going to watch that very closely. And if, for example, you try to sponsor you get remarried and you try to sponsor a spouse within the 5-year period, then it means that they have a they are going to deny it. They're going to deny it, and it can open up a whole can of worms because they have to presume they have to presume that this they're going to assume that it was not a real marriage, your first marriage. They're going to reopen the previous marriage case, so the one where you got the green card, and you're also going to have to show by clear and convincing evidence that the current spouse that you have is a bona fide marriage and relationship. So usually you have to make sure that you're looking at timing and that you're considering the risk involved. Anything within 5 years of getting your green card and divorce in the US citizen spouse is going to raise scrutiny, and they are going to deny it unless you can really meet their standard of evidence. Thank you so much for the love on TikTok. I appreciate it. The more you tap the screen, the more people are seeing this live and they're getting information that empowers them in this process. So go ahead and keep hitting the likes. All right. So I'm going to go to how long do I need to stay in the US before submitting my adjustment of status for EB1? So when it comes to adjustment of status, applying for adjustment of status, it's not necessary. You have to maintain your legal status right up until the point you are qualified to apply for adjustment of status. So, for example, if your priority date is going to be in a year, but you only have 6 months here in the US, adjustment of status, you're not going to make the adjustment of status. You're not going to meet the requirement to file adjustment of status. So, it's all about timing. It's about what your current status is and whether you can keep that status for as long as it will take to qualify for adjustment of status. And this is where, guys, it's important. It's complicated stuff. And this is where you need to make sure that you're talking to an attorney. I'm giving you basic information here, but you really need to make sure that you are talking to an immigration attorney like me, like the lawyers at ST Law Office, to be able to understand how the law applies to you, how you qualify in order to move forward correctly. All right, so I am now on TikTok. So go ahead and put your questions in. I'm seeing a ton of questions. Hi there, Sasha. Nice to see you. Can I travel to Morocco with expired green card and I-751 waiver pending? No. So you have an expired green card, and you said you have a waiver pending, but do you have an extension letter? You need to have that. It's usually a 48-month extension letter that says that you continue to be a green card holder, and that extension letter is evidence of that. If you travel out of the country with an expired green card alone, with a waiver, an I-751 waiver pending, it's likely they won't even let you back on the plane to come back here. So make sure that you are applying you get that extension letter before you travel. Is VAWA timeline faster this year? No. You can go ahead, go to uscis.gov, and you can check the processing times there. Go to case processing times, and you'll see the range of time that it's taking. Thank you. Wow, 2.1K likes. Thank you. That is what is helping me to be visible before people so that they can get information that empowers them in the process. Can a US citizen apply for citizenship for his child who was born and is out of the US? Yes. So we have done this for our clients where their child was born outside of the United States. And then what we do is we go ahead and we submit a special application and we set a special appointment at the embassy for the child to be registered as a US citizen. So usually if once a child is born and you meet certain requirements, the child is actually a US citizen, you just have to register their birth. And so, yes, absolutely. But there are certain requirements, and it comes down to who is the U.S. citizen. Is it both parents? Is it one parent? Are the parents married? That will count as to what we need to show in order for your child to get their passport and be registered as a U.S. citizen at the embassy. What is the VAWA real timeline for who applied on April 2024? Look at the case processing times on uscis.gov. I do have an idea of the timeline, but I don't want you to hold me to it. I want you to be able to see the range of time that it's taking, because every case is different. And so they have the shortest timeline up to the longest timeline. Go to uscis.gov, go to case processing times, and you'll see there. Can I apply for advanced parole while I-485 is pending, 3 months family-based petition? I overstayed. Yes, you can apply for advanced parole. Advanced parole is basically the travel document. Just be very wary of your risk. Each person is going to carry a certain risk when they travel. Usually, if there's a criminal record involved, if there's any kind of questionable conduct on your application, and if they are really scrutinizing your application for fraud, I would be very wary about traveling. I would wait till your process is finished. And I'm conservative on that. So I advise against travel if possible, but if it's something that you really need to tend to, then talk to your attorney, make sure that you fully understand the risk involved, because having advanced parole does not guarantee that they will let you back in. It's saying, if you're going to leave the country, here's what you need to get back in. But when you come back, they can run a background check. They can look at your application and decide whether they want to let you back in. So, and we're seeing more secondary inspection, more situations like that now, of course, so you want to be careful. How is VAWA going lately in the process? So no case is simple. You should not be entering any case assuming that your case is going to be simple. The reason being, they're really screening and scrutinizing these applications, and they're looking for fraud. And as you have probably heard, they're also re-reviewing past applications where people actually got their green cards to determine whether there is any fraud or do these people really qualify for the benefits. So what we're seeing in the VAWA process is we're seeing an increase in requests for evidence. We're seeing that they're really nitpicking at certain aspects of the applicant's background. So for example, I talked about the common law marriage issue in Jamaica. So Jamaica does allow for common law where you don't necessarily have to go do a traditional marriage ceremony. You can live together for 5 years and put yourselves out there as a married couple, and you are considered a common law you're considered to be in a common law marriage. Well, we're seeing now where they're using that when they find evidence that the person was in a long-term committed relationship, they're actually now saying that was a common law marriage. And because it's a common law marriage, your marriage that you're basing the VAWA on, or your marriage that you're basing the marriage green card on, is not valid because you didn't terminate the common law marriage. So it's about countering that, of course, because they're the clients in the cases that we're dealing with. Our clients were not in a common law marriage. They did not put themselves out there like that, and they didn't even spend the amount of time needed for them to qualify for common law marriage. But these are the examples. The other one are divorce decrees. That seems pretty simple, right? So they send a request for evidence and they say, give us your divorce decree, or your divorce decree we're not accepting the current divorce decree. You need to show that this is a real divorce. So we're seeing that, for example, in Nigeria, we're seeing a pattern where they're now accusing many individuals of getting fraudulent divorce decrees in their country, like in Nigeria. But many of these individuals hired lawyers in Nigeria to do this. And so, it's adding complexity to their case. So this is just to show how they're nitpicking. And it's important to have an attorney that can really hone into that and make the legal arguments necessary to overcome that. Because when you get a request for evidence, it does not mean you're denied, but it means they're giving you a last chance to show that you can qualify, that you can overcome whatever they're telling you. So it's a challenge, and you need to be ready for it, because that's what's happening. We have to work a little harder to get to the success. Oh, thank you so much, Judith. I appreciate that. If VAWA is pending and received a notice to appear, do you qualify for any form of relief? So, in the case your VAWA is pending and now you get a notice to appear, in a case like that, we would raise it with the court so that you do have a pending VAWA case. Now, there are two ways to approach this. One is you raise the pending VAWA before the court and then assert it as a defense to removal, because there is VAWA cancellation of removal as well. And in some cases, the judge is to put forth a continuance where the judge would then delay the immigration court hearings to allow time for the adjudication of the VAWA petition. And oftentimes, if the VAWA is approved, then the judge will turn around and say, okay, they're going to terminate the removal proceedings in order for you to move forward with the VAWA process and the VAWA adjustment of status process. So it can be a process, but that is going to have to be the approach here. So now raise that issue before the court. All right, keep putting those questions in the comments. How long will it take for spouse visa, the I-130 petition? So how long it will take? So usually I-130 petitions for a spouse, it can take up to a year. So I usually say 9 months to a year to get an approval to be able to get to the next step. But as usual, go to uscis.gov, go look at the broad range of time, because I'm just telling you based on my experience as an attorney dealing with these cases, that's what we see. But every case is different. And so it's important for you to see the full range. Okay, so my husband is waiting for appointment at the in Juarez. What should he carry with him at all? So usually when our clients are going for consular processing at the embassy, we create a whole packet. And it depends. What's in the packet is going to depend on what the application type is. I'm assuming that this is a marriage-based uh, consular processing case, but there are certain things that all cases have in common. And I would say it's important for you to make sure you talk to your attorney. I don't know if you have one, but make sure you talk to your attorney. Make sure your attorney gives you information about what you should take with you. But civil documents, having your original civil documents, like birth certificate, marriage certificate, divorce decree, and bringing a copy and originals is very important. Usually there's a website you can go to at Department of State that also provides you the information with the specific to that location, what you should be taking with you. The medical is going to be very important. Make sure that you get that done in advance. Some cases, they are sending the medical directly to the embassy, but make sure you get that done way in advance so that by time the interview comes up, it's not a missing item and the officer can make a quick decision. The affidavit of support is super important. That is one of the documents that causes a lot of delays when it's not done properly. I often, when my clients are going in for an interview, we make sure that the I-8, the I-864 is signed. Make sure we have the original signature. We also make sure that tax documents are updated and pay stubs are updated. So if the officer asks about any changes or asks to get updated proof that the sponsor has sufficient income, that is already provided, and also providing the most recent tax return. So if you provided tax return 2 years ago, now what we do is we update that to make sure the most recent tax return is attached with tax statements. That's very important. If you have your tax transcript, you don't need a tax statement. So that in a nutshell, I would say are the items that you need to pay attention to. My daughter's student visa was denied in Jamaica. Can she enter the US before it expires? So, if chances are, I don't know when the first one expires. But if she's entering, there would be questions, right? Because if it's about to expire and she's trying to enter the country with the visa that's about to expire, the next question is, well, how does she plan to finish her studies if she's coming in on a visa that is just about to expire? So you're definitely going to come by some obstacles and may be turned around. Furthermore, being denied the visa means that there's not the intention for your daughter to be able to benefit from the student visa, and so she may be turned around trying to enter with that student visa. So it's questionable. Please, how can I become an American citizen? So, one thing that's very important is being a US citizen and being a permanent resident are two different things. So, I'm assuming if you're a permanent resident, then you have to have it for at least 5 years. When you have it for 5 years, you also have to show physical presence, continuous residence in the United States, and good moral character. If you're married to a US citizen, then it's going to be 3 years, but you have to show that you're living in marital union with a US citizen. And so the timeline, if you're in the military, then it goes down to 6 months. So that in a nutshell would be the requirements. So if you meet that timeline, that's great. Now, if you're talking about permanent residence, meaning you want to come here first and become a resident, then in that case, there are various ways to do it. It just depends on how you qualify. Do you qualify? Um, do you qualify through employment? Do you qualify based on your family members? Do you qualify based on humanitarian reasons? That's where it's important to definitely talk to us to determine what the best option would be. All right, I'm gonna go over to Facebook and YouTube to answer questions there. What about the 39 full ban country? Is there any news? So no, not at this time. There are no developments really. How fast can a habeas corpus be filed if someone who overstayed their visa is detained but has married a citizen? So there are emergency filings that can be done very quickly, as long as you can find. It depends on the jurisdiction. So if you have to find an attorney who is admitted in your jurisdiction to be able to file that very quickly, and it also depends on the basis. So. They overstayed their visa and they're married to a US citizen. Do they have a pending process in place? There would have to be legal questions that would have to be answered as well. But it can be done very quickly, especially with emergency filings. If you owe taxes and you have arranged a payment with the IRS, does that affect your green card process? Not necessarily. So I don't know if you're the immigrant or you're the petitioner. Usually they're looking at the taxes of the petitioner, not necessarily the immigrant. But having a payment plan in place means that you're complying with the law, that you are making payments on those taxes, and millions of Americans have to do that. That some people can't come up with all the money at one point and they have to do a payment plan. And that's okay because you're still complying with the law to pay your taxes. A friend having a niece of 29 years old, single. Okay, so a friend having a niece of 29 years old, single, daughter of his late bro, bearing the same surname. Can she assist his uncle, married 50 years, to file paper, both in the US? So this is a lot, but it's looking like a niece wants to see if she should be able to get her papers through the uncle, and no, not directly. So usually siblings can sponsor, which is still a very long time. So that if you're here in the US, you've already overstayed, it's not going to work. It's not a quick process. It's at least 14 years for a sibling to sponsor a sibling. But what happens is any children who are under the age of 21 and unmarried can go along with the immigrant sibling. So aunts, uncles can't sponsor a niece or nephew directly, but the niece or nephew can be sponsored indirectly as a derivative of the immigrant sibling. How long does it take the T visa receipt notice to come? So I would say we're seeing faster turnaround to get the receipt notices, but I would say 2 weeks to up to 4 months to get that receipt notice. What are some VAWA I-485 interview questions? So what they're focusing on with the VAWA is they're mostly focusing on, do you know what's the facts? So they're focused on, do you know what's in your declaration with the VAWA? They want certain specifics about the mistreatment that occurred. Sometimes they may even touch on privilege questions. It's very important you understand the limit on that. So if they're asking you questions about what you and your lawyer talked about, what did the lawyer tell you about VAWA? How did you sign up with a lawyer? How much did you pay your lawyer? That is privilege information. And it's important to make sure that you uphold that privilege, because if not, and you disclose the information, then you're basically opening the floodgates for them to access all privilege information. That means that this very sacred relationship between the attorney and the client can be broken if you reveal any inside information with your attorney, and that's your right. So just be wary of those questions. I've gone to interviews before, and I did not get these kind of interviews, these kinds of questions until lately. But those questions were raised, and I simply objected and let them know that these are privileged, and it was fine. But it's important for you to know the differences there. Now, they may ask questions about living together, dates, times. It's very important for you to just make sure you have your facts ready, that you refresh your memory, you review your declaration. And then now, there are two approaches. There's the VAWA, and then there's the I-45. So usually if your VAWA is approved already, the officer may not touch on, anything about the abuse or mistreatment, even though now in their policy, they said that they can ask if they suspect that there's any kind of fraud involved. But usually what they're focused on now is admissibility. So they're focused on whether you have anything in your background that's going to disqualify you from finally getting the green card. Because remember, the VAWA is a two-step process. You get approved for the VAWA, you get protection, and then they process you for the green card. At that stage is where they want to know, do you have a criminal record? Do you have any kind of immigration violations that can disqualify you from getting the actual green card? All right, I'm back on Instagram. Put your questions in the comments on Instagram. Need to adjust the children's status? Give us a call and let's talk and get started. Is it a good time to file for VAWA? You qualify? Yes, it's a good time. Absolutely. You need to make sure you're seeking that protection. Get in touch with us. Let's talk about whether you qualify. I have a question. If I'm married to a US citizen, but I came here on the border without a visa and I apply to adjustment of status, do they gonna ask me to leave the country to wait for the green card? So if you enter the country without permission at the border, or even if they picked you up after entering the country at the border, and you were not given parole, then it's likely you don't qualify for adjustment of status. To qualify for adjustment of status, you need to either be paroled into the country, or you need to show that you entered with a visa. So, I would say don't count yourself out. This is where, though, you make sure you schedule time to talk to us or an immigration attorney at least to let's sift through the facts here. But coming through the border and not being paroled means that adjustment of status is not going to be that simple. How long am I supposed to be in the US before getting married to a US citizen with my visitor's visa? So usually there is a presumption of fraud if you do these things within 90 days of your entry. If you get married, if you work, or if you file any documents that, for permanent residents. So usually 90 days is at a period where that is going to be unsafe to do any of that. My husband came to the US at 6 years old. We got married in 2014 and have a 13 and 10-year-old. Do we apply for our I-130? So if he came to the US at 6, I would want to understand how he came. If he came through the border or he's unable to show how he entered the United States or unable to have proof that he had a visa, then adjustment of status may be questionable here. And usually there's another type of process, or we look at alternative options. Now, if your husband came in at 6, but you can show, or he can show, or we can find that he entered the country with a visa, then adjustment of status would be fine. You said, do you apply for an I-130? You may already know that, okay, so I see here he came illegally. Okay, great. So if he came illegally, then do you file the I-130? I would say this is definitely a conversation to have with an attorney. The reason being, filing an I-130 alone has its own risk. Filing an I-130 and while being in the United States can mean that it can, he, upon reviewing the I-130, seeing he's in the United States, seeing that he's not qualified for adjustment of status, can trigger them to issue a notice to appear. So you'd want to basically understand and so in order for him to move forward to get permanent residence, you'd have to get an I-601A waiver. I-601A waiver, though, is usually issued at the point where the adjustment, the I-130 is approved, and it's time to move forward to the consular processing at the embassy. So if you don't have an attorney already, definitely talk to an attorney to come up with a plan. The thing is, here's the catch: you cannot get to the I-601A waiver without first filing an I-130. So, this is what you need to explore. All right, 8.9K likes on TikTok. Thank you so much for that. Is it reckless driving charge affect to VAWA? It depends. I would say it depends on the facts. Reckless driving by itself, not necessarily, but you still have to answer to the evaluation of good moral character. So that in that case, you definitely want to ramp up evidence regarding good moral character. But reckless driving by itself does not render you inadmissible. But I'd have to understand the facts as well, because say reckless driving involved a victim or it involved injuries, then it may definitely be looked at differently. A U.S. citizen spouse as an IR1 resident, can he do something with green card after entering in the U.S.? So an IR1 resident usually means they're a permanent resident. So I'm not sure where the disconnect is. But if he's coming, so what happens at the embassy? He's given a visa, right, in the category IR1, he or she, and when they come to the U.S. And enter the country, they're gonna become green card holders. So they give them a stamp in their passport, and then they send the card shortly after. Pending asylum, traveling by Greyhound bus, NYC to Virginia, still a risk. Yes. So they can stop, Greyhound buses and check statuses. So yes, it is a risk. What if you have a 2-year green card and your wife don't want to file with you and your card is going to expire? Get in touch with us. We deal with these cases. If your spouse doesn't want to apply with you, first of all, I would want to understand what's going on in the marriage. It could be simply that it's not working out, and that's okay. There's a waiver for that, meaning if it's not working out, you're going towards divorce, you can apply based on divorce. But if your spouse is not looking out for your interests, mistreating you, then we can look at another type of waiver based on the mistreatment. And then there's another type of waiver that allows you to apply by yourself if you have extreme hardship. So we want to know which one or whether we can do multiple in order to move forward. I'd say it's urgent at this point. The good news is when you qualify for a waiver to apply on your own, you can apply at any point. So you can even apply months, say 6 months, a year before your card expires, and you can give yourself a head start. So get on it. My schedule is filling up though, guys. So call, schedule with me. Let's talk and figure out the best option forward. But yes, you're going from a 2-year green card to a 10-year green card. Spouse doesn't want to apply with you. It's not the end of the road. There are ways around it, but you must apply for a formal waiver. And even if you've applied to have the conditions removed and your spouse leaves you in the middle of the process, you can still submit the waiver, but you must submit this waiver in order to be successful in your process. Oh, thank you for that, Mr. Eric. I appreciate that. All right. As much as I want to stay here with you all, I have to go because I have to sleep, get up, and do it all over again. So thanks everybody for your time. Our VAWA case is still approved? Yes, yes, yes. VAWA cases are still being approved. We just got one last week, but you must make sure that you do this the right way. One thing I have to say is we're seeing an increase in requests for evidence. And with this client that got approved, we had to respond to 2 requests for evidence before we got her approval, but we did get their approval, absolutely. VAWA, T visas, these are still moving forward with approvals. It's immigration, even though a lot of things are happening, a lot of scary things are happening, we are still pushing forward with processes that are in place because it's dictated by the law. Nobody can erase that law, right? Only Congress can come in, and they have not changed any of the laws. So if you qualify, now is the time. Don't sit and sit on it. Make sure you call us, talk to us. We're a safe space. Let's figure out what works best for you and then move forward with our process. So start with a consultation with me. You can do that by you can go to the link in the profile. You can call the number. We have the lines running 24/7. So call the number and then we will call you back first thing to schedule your appointment. But yes, processes are still moving forward. All right. As much as I want to stay and answer questions, I have to go. Thanks so much again for your time. As always, like, share, subscribe, hit the notification bell. That will allow you to see when I come on so that you can jump on with me if you're available and I can answer questions. All right. So have a good night. Bye-bye.